Thank you, Nadine, for coming.
Oh, thank you so much for having me.
Coming back home, is that fair to say?
Home to the ACLU national headquarters and also Sullivan and Cromwell.
I was talking about Sullivan and Cromwell, but as you note, the ACLU lives here too, so and home in both respects. So I'm going to read Nadine's biography, although I'm sure you're all quite familiar with it. We're honored to have her, S&C alumna, Nadine Strossen, to speak to us about her new book, Free Speech, What Everyone Needs to Know, in which she provides an original comprehensive framework for integrating the Supreme Court's many disparate free speech rulings into a coherent overall scheme. Nadine is a New York Law School professor emerita and former national president of the ACLU from 1991 to 2008. She is also the author of, among many other books, Hate, Why We Should Resist It with Free Speech, Not Censorship. The National Law Journal has named Nadine one of America's 100 most influential lawyers, and several other publications have named her as one of the country's most influential women. Her many honorary degrees and awards include the American Bar Association's prestigious Margaret Brent Women Lawyers of Achievement Award, and in 2023, the National Coalition Against Censorship, an alliance of more than 50 national nonprofit organizations, selected Nadine for its Judy Blume Lifetime Achievement Award for free speech. So let's give a warm welcome to Nadine.
Thank you so much.
And just to note that after this talk, there will be a cocktail reception and book signing next door where you can get a free copy of Nadine's book for her to sign.
If I may, to return the very nice introduction, Tom, I'm not sure if everybody knows about your important leadership role in the free speech realm. I had the pleasure of meeting Tom through an important new, semi-new organization that was founded a couple of years ago called the Academic Freedom Alliance, which is an essential organization, unfortunately, with all of the attacks on freedom of thought against professors, even those with tenure. It was felt necessary to provide an organization that would support any professor whose intellectual freedom, academic freedom rights were under attack. And all of us who are leaders and supporters of the organization are pledged to come to the defense of the free speech rights of anybody, even if we strongly disagree with their ideas. I thought about that yesterday as I was speaking at an event in Philadelphia, and the infamous Amy Wax, who was one of our clients, was there. But Tom is the chair of it's called a council, the legal council, which is one of the two major institutions that are running the organization. So your leadership is very valued.
Well, thank you, Nadine. We're here to talk about your book, and I don't want to sound too much like Oprah here. Did the junior associates know who Oprah is? Okay. But I really enjoyed the book. I think that the book would be a great horn book for somebody taking a First Amendment class in law school, because it does a great job of laying out a lot of different areas of law in a really organized way. But it was also very digestible and readable for a non-lawyer. So I really would commend it to anyone, law student, lawyer, or non-lawyer alike, for a great overview of the First Amendment case law. And one of the things that I thought was particularly excellent in the book is the respect that you have for the reader. Mm-hmm. And what I mean by that is you introduce the issues. And I think one could surmise your view on a lot of the issues, but really in the end, and I open it to you to explain why you wrote it this way. You're laying out that there are complicated issues and that there are arguments in both sides, that there are harms to free speech, but there are also many benefits. And even though you come out in favor of freedom on a lot of these issues, as I read the book, you do so in a way that's with a very light touch and with respect for the reader. So I observe that and open our conversation with the question for you, which is, what were you trying to do with this book?
Oh, thank you so much, Tom. That's really about the greatest compliment I could receive, because both as an educator and an advocate, and I've had those dual roles for many years, my goal is to open people's minds and to stimulate their critical thinking. It's the opposite of indoctrination. And I say that even in my capacity as an advocate, but certainly in my capacity as an educator. The mantra that I had for my students, and I still have it for everybody with whom I have the privilege of engaging, is my goal is that you will be able not only to answer every question, but also to question every answer. Certainly in law school, this is the norm, right? My students were told that they must be able to understand, articulate, and advocate all plausible perspectives on every issue that we studied. And by plausible perspectives, that means perspectives that are backed by relevant evidence and analysis. Since I was teaching constitutional law, the Constitution, Supreme Court precedents, interpreting the Constitution, your own reasoned analysis of the language. And I think, in law school, we all hear that we're being taught to think like lawyers. Tom, in my view, that is being taught to think, right? And I think that's the mode of analysis and education that we should inculcate at the earliest possible ages. This is becoming a more urgent issue as we find, rather than other lower units of education not becoming like law schools in being exposed to different perspectives, but law schools, unfortunately, are succumbing to the pressures that we're seeing at lower levels of education to, in fact, not expose students to perspectives that they find to be offensive or that they want to reject. Now, I brought one prop with me, which is why I insisted on toting my bag up here, and it does relate to your question, Tom. So I'm gonna haul it out here, and don't get too excited. You think you know what this is. The print is kind of small, so you're gonna have to read it aloud.
Okay, it says, "Make John Stuart Mill great again."
Yesterday I spoke to a Federalist Society chapter. They were so disappointed. And this was a gift from a human rights organization in the Czech Republic. I want to mention that just in passing, because the issues that I discuss in my book and the issues that we work on in the Academic Freedom Alliance are not only of concern all over this country, but they are truly of worldwide concern. And although my book uses First Amendment principles, I stress that I am citing those by way of example, because the principles that are reflected in current First Amendment law, sorry, I talk too much, so I always losing my voice.
They're here to listen to you,
Thank you
Nadine.
so
It's
much.
not to listen to me.
Those principles are reflected and embodied in international human rights law and in the free speech law of just about every other country. There are some exceptions, to be sure, but despite critiques that United States First Amendment principles are exceptionalist, the truth is there is an extraordinary amount of overlap with the law in other countries. And So anyway, going back to John Stuart Mill, I keep rereading his classic work on liberty from 1859, which to my mind continues to be the most persuasive, eloquent justification for questioning every single idea, every single value, even the ones that we hold most dear, indeed, especially the ones we hold most dear. So in my case, that means questioning fundamental civil liberties and constitutional rights principles, including those about freedom of speech. Tom, since you're so kind to have read my book, you know that the very first substantive chapter, I lay out what I consider to be the 12 strongest arguments against free speech. And I give my strongest responses, but I invite readers to rebut me. To me, that's a favor. So along with Mill, he says there are logically only 3 possible consequences of re-examining an idea. Number 1 is you'll re-examine it and conclude that you were wrong. What a great benefit to be relieved of the burden of laboring under a false misconception. The second possibility, logically, is that you will basically reaffirm the pre-existing idea, but with some refinements and new depths and nuances of understanding. And I will say, Tom, that's what happened to me as a result of the process of writing this book. I developed some refinements and enrichments in my understanding of the First Amendment, of free speech principles, some modifications. The third possibility is that you will be completely reaffirmed in your pre-existing beliefs, but that is still a benefit because as a result of having re-examined and revisited the reasons and the analysis underlying your pre-existing ideas, you understand them more deeply. You're able to articulate them to yourself with more refinement, and you're able to articulate those ideas more persuasively to other people.
Mhm.
So that was a wonderful process for me to go through. I'm continuing to go through it, and that's the process that I want the reader to bring to bear, that this will stimulate your ongoing thinking about these very difficult issues.
Is this the same point, or is there a difference with, I think it's in your conclusion, but it's the thrust of the book, I think, in many ways, that the right to freedom of speech has to be refought for, in a sense, by every generation. Is that what you're talking about with the re-examination and the importance of that? Or what were you hoping that the reader would take away from that?
The reader would have renewed, if not, initial understanding of what freedom of speech principles are. And I have to say, there is so much ignorance on that score, including shockingly among lawyers and law school graduates, including public officials. I can't tell you how many, which I'm very sensitive to, you may have noticed it as well, how many government officials who are law school graduates will say things such as, that's hate speech, not free speech. When of course there is no hate speech exception to our First Amendment, rightly so. And what I've found is that the more information people have about what First Amendment free speech principles actually are and how much they accord with common sense, the more information people have about the history that gave rise to those principles and what the dreadful experience was before that under a more censorial regime, the more support there is for free speech. So even though I separate my roles as educator and advocate, they really overlap because, and surveys have shown this, that the more people actually understand free speech principles, the more they support those principles. On the issue of the ignorance of lawyers, Tom, when I went to law school, First Amendment was a required element of the required constitutional law course. That is not the case anymore at most law schools. Constitutional law is still required, but only the structural elements and often some equal protection. So there are actually many graduates of some of the best law schools in the country, as well as others, who literally have no knowledge except maybe what they can pick up in the bar review course.
Yeah. I mean, one of the things you talk about in the book is the concept of the heckler's veto. And there was a well-publicized incident with Judge Kyle Duncan, right, at Stanford, where he was invited to campus. I don't remember by whom.
The Federalist Society.
Federalist Society, yeah. And folks were there protesting. But I think it's an interesting dilemma, because on the one hand, Judge Duncan should be free to speak his mind. But on the other hand, the protesters ought to be able to speak their mind as well. And so how do you reconcile, competing desires to be heard, right? With first the robust understanding of the First Amendment that you're advocating for here.
This is a perfect illustration of the common sense nature of First Amendment free speech doctrine, as I alluded to earlier. On the one hand, of course, there is a freedom of speech, not only for a speaker to convey information and ideas, but also, let's not forget, of audience members to receive information and ideas. On the other hand, of course, there is a right of peaceful, non-disruptive protest. And those adjectives are really important, because if it is non-peaceful and or disruptive, that is violating the free speech rights of audience members and speakers, as is true for all legal principles, or most of the interesting legal principles. There's a matter of judgment and degree. There is obviously no bright line between a disruptive and a non-disruptive protest. And we've seen debates, including at law schools. I remember there was a debate at CUNY, was one of the first instances of a law school deplatforming a speaker. And the protest went, the speaker was going to talk for an hour, maybe 50 minutes, and the noisy protest that was preventing him from being heard went on for about 20 minutes. The dean of the law school said, oh, that's not a sufficiently substantial disruption, because he still got to speak for 30 or 40 minutes. I personally disagree with that, but I can't say it's an objective scientific test. The term heckler's veto was coined by the Supreme Court. Well, actually, it was coined by Harry Calvin, a great First Amendment scholar at the University of Chicago in the 1960s. The Supreme Court adopted that term in the context of the civil rights movement, because the heckler's veto was one of the major tools that was used against Martin, well, it's Black History Month, so how appropriate, against Martin Luther King and other pro-civil rights demonstrators, in a designed attempt, which unfortunately too often succeeded, to shut down their demonstrations. And the Supreme Court said that's an illegitimate violation of free speech.
Interesting. The Constitution, maybe I'm getting a little bit too abstract here, but I do think I find the history very interesting. And one of the points you make in the book is that the version of freedom of speech that you discuss, and I would say advocate for in many respects in the book, is really a post-1950 or second half of the 20th century version of the freedom of speech. And the question that occurred to me reading the book, because I don't know the history, keys off of the fact that the Constitution says Congress shall make no law violating, abridging the freedom of speech, right? Which suggests that when the Constitution was adopted, there was an understanding of what the freedom of speech entailed. And so the question for you, or the question that I had, I should say, reading the book is, what was the freedom of speech that folks thought they were signing up to? And is that still the freedom of speech that we enjoy today?
Wow, you are channeling my dear departed friend Nino Scalia and taking an originalist approach to the Constitution. And I used to tell my students that, it might seem as if the First Amendment free speech clause is pretty straightforward. Congress shall make no law abridging the freedom of speech, but every single word has been subject to debate and dissent. And I would surprise my students by saying, even the word "the," and you have exactly hit upon one argument that it raises. To the very, very best of my knowledge, even ardent originalists say that approach to the First Amendment is not particularly helpful because there simply is no information available. And I know, and I've debated Nino about this, his answer would be, well, we have to look at not the original intent of the framers and the ratifiers, because admittedly there's no documentation, but the original public understanding, what was the accepted concept of freedom of speech at the time. And there, as is true of all historic issues, just as is true for all legal issues, historians disagree. And so some historians will say, but the Alien and Sedition Acts were enacted only, a couple of years after the First Amendment was ratified, as you all know, that basically outlawed criticism of government officials. I mean, so does that mean that what we think of as the most precious aspect of free speech in a democratic republic, the right of we, the people, who wield sovereign power to criticize those we elect to be accountable to us? So some people make that argument. I think it's clear I don't consider that particularly persuasive. And other people point to even a pre-revolutionary history in this country of what, to cite the title of one book on point by a professor at NYU, Steve Solomon, Revolutionary Dissent, that this country was born through a very vigorous process of dissent that included not only speaking and writing, but all kinds of expressive conduct, including probably the Boston Tea Party is the best known, but government officials were burned in effigy. There were freedom polls. And so the argument is, if you're looking at the original public understanding, there's a lot of support for an extremely robust concept of free speech, including the right to criticize, including falsely criticize government officials.
Pivoting to something that's related to that, but something I marked my book on. Are you familiar with the concept of reframing as psychiatrists or psychologists use it? So the concept, I might be getting it wrong, but as I understand it, is any challenge in life that's presented to you could be viewed with fear or anxiety, and you could run away from it. Or even the hardest challenges can be reframed as opportunities in some way, to grow, to learn, whatever. I think it's a helpful and interesting concept. And when I read something you said in your book, which we don't hear a lot about, I think is related to this, which is two closely related points, which are free speech isn't treasured because speech is harmless. Speech can be very harmful. But the other point you make is related to this reframing idea. It's an opportunity to be resilient, to grow in resilience. So can you talk to us a little bit about that thought, which I haven't heard really from anyone else in the free speech debate. And I thought it was a very important contribution.
Well, thank you. And one of the reasons I love speaking so much is I always learn. So now I learned a concept and a term, which I certainly have invoked, but I will not take credit for it. The idea that being subject to speech and ideas that you find challenging, or worse yet, disturbing, offensive, insulting, that this can be an opportunity for you to develop resilience and to resist being somehow undermined or subordinated by the speech. That concept, I think, was, to my mind, first very strongly developed in a wonderful book that came out in 2018 called The Coddling of the American Mind, co-authored by Greg Lukianoff, a lawyer who is the president and CEO of FIRE, Foundation for Individual Rights and Expression, and significantly, Jonathan Haidt, a distinguished social psychologist who teaches at NYU. And as a result of his own mental health challenges, which Greg very openly describes in that book and other works, he started to have the perception that the arguments that were being made and accepted on many campuses, that we want to shield students from hateful speech, from provocative ideas, from insulting words, in order to benefit them psychologically and emotionally. Greg said, well, you know, that's exactly the opposite of what I'm learning through my cognitive behavior therapy approach to mental well-being, which is we have to surmount, we have to not empower speakers to change our sense of self-confidence. We have to look down on them for having these negative ideas, and we have to have a sense that we are better than whatever words that they are hurling at us. I think that this is a, shall I say, mature enough audience that I will dare to quote another friend of mine, Jonathan Rauch, who is a fellow at the Brookings Foundation. Jonathan is a lifelong advocate of LGBTQ rights, a gay man himself. He was advocating same-sex marriage, marriage equality decades ago, long before it was adopted, even by mainstream gay rights organizations. So he's got real credentials in this area, but I'm going to have to give you a trigger warning. And I wouldn't say this in most campus audiences. I wouldn't quote Jonathan, but in his most recent book, The Constitution of Knowledge, he's making this point about, you know, the fact that somebody may use a gay, gay baiting slur against me isn't going to harm me. And here's the way he put it, which I thought was very memorable. He said, if somebody calls me a fucking faggot, I process that as she needs counseling, not that I am a fucking faggot. And so I think this notion that we are doing some good for our young people or others by shielding them from certain words is really not only inconsistent with freedom of speech, but it actually is inconsistent with the supposedly countervailing goal of their mental health and well-being.
So sticking with the university topic for just a second, what was your reaction to the congressional testimony from university presidents, but then the reaction to the congressional testimony? I'm wondering how you thought about those issues in that context.
I've thought about it and talked about it a great deal. And first of all, a Congress a congressional hearing is, as people know, a political event. So this was really not an exercise in what is the law. There clearly was an effort to embarrass the presidents, and on the part of many members of Congress to exert pressure against academic institutions, which is itself a threat, or at least a potential threat to academic freedom. The concept of academic freedom, which was flourishing, well, first flourished in this country at the beginning of the 20th century. We adopted it from great German universities that began institutionalizing these norms at the end of the 19th century. And the first element of it is institutional autonomy on the part of the universities to be free from external political or economic pressure, that they should be free to constitute their own communities, create and design their own curricula, to engage in a pursuit of truth, guided only by scientific and social scientific concepts of truth finding. So there is that potential concern, including from the fact, I'm not sure how many people know, that there have been ongoing inquiries and demands for turning over documents and records that I think are saber rattling against the universities, which is concerning. That said, as somebody who strongly advocates academic freedom on the part of individual members of the university community, as well as the university as an institution, I was dismayed by the president's performance because it was so hypocritical. And, you know, everybody has talked about this, so I don't want to belabor it. I think this has gotten quite a bit of publicity, but since I'm very involved with FIRE, let me say, for the past 6 years, FIRE, together with College Pulse, has been doing a very detailed analysis of the state of free speech on campuses around the country. Last year's report, which came out in October, closely studied 248 campuses. Of those, Harvard was number 248, wow, and Penn was number 247. So for the presidents of these universities to say, oh, we believe in free speech, freedom, even for insulting, hateful, violent advocacy, quite frankly, that is not true. They were succumbing to all kinds of pressures to suppress so-called microaggressions against every other type of person or group. And I understand why many of my Jewish friends were concerned that this was just an opportunity to give a pass to anti-Semitic speech, which would not have been given to anti-Black, anti-gay. And as with every equal protection problem, we know that we can solve the problem either by ratcheting up or ratcheting down. I am dismayed that some of my friends, including my anti-Semitic friends, are saying, well, now we should make sure that anti-Semitism is added to the category of expression that's going to be considered microaggression and subject to restriction. And I and others in the free speech camp have been saying the opposite. Let's use this as an opportunity to increase protection for free speech, regardless of who is the target of the offensive speech. But there's one other point that really has to be stressed here, which is, technically speaking, the presidents were completely correct when they said advocacy of genocide is or is not protected under free speech principles, depending on the context. That is a correct answer legally. I said earlier that free speech principles make a great deal of common sense, and they really do. They empower government or universities, in this case, to outlaw and punish the speech that is the most dangerous, speech that in particular facts and circumstances, a particular context, directly, imminently threatens or causes certain specific serious harm. So a targeted threat, or targeted bullying or harassment, or intentional incitement of imminent violence that's likely to happen imminently. Those are all context-based situations where a message that in its content advocates genocide can and should be punished. But if you're just looking at an advocacy of genocide content to the message, and it's not in a specific context that is causing or threatening imminent harm, say it's students that are standing in an open area of campus chanting slogans that may or may some people will experience as genocidal, they have a right to do that. You know, in 1969, when the Supreme Court started to very strongly finally enforce freedom of speech in an ACLU case, I'm proud to say, the Supreme Court unanimously held that even advocacy of violence is constitutionally protected. It crosses the line and is unprotected only when it becomes intentional incitement, and incitement was distinguished from advocacy, of imminent violence that is actually likely to happen imminently. And that not only was that adopted unanimously in 1969, not a single Supreme Court justice since then has disagreed with that holding. So in many contexts, advocacy of genocide is constitutionally protected. Sadly, there's a lot of evidence that in many contexts, on many campuses, the line has been crossed to targeted harassment or bullying, and there is some concern that those, you know, the limits on protected speech have not been enforced.
How do you apply, in your thinking, that test which you've articulated to the topic of doxing? Mm-hmm. I've only recently learned what the term is, where you're de-anonymizing someone and publicizing their name, you know, widely. It seems to me an interesting issue for somebody who cares about free speech. On the one hand, and I think you talk about this in the book, there's value in anonymous speech. The Federalist Papers were written anonymously, for example. On the other hand, it does seem very targeted and arguably could constitute harassment. So have you given any thought to doxing?
A lot of thought. And as you know, as is true for a number of free speech issues, not only is there a tension between freedom of speech concerns on the one hand and privacy concerns on the other hand, as you've so well laid out, Tom. But actually, when you think about it, it's even more complicated because there are freedom of speech concerns that are weighing against each other. If you are afraid that raising your voice to advocate a position might lead to doxing, and which can threaten your livelihood, as we've seen with law firms saying that they're not going to hire students whose names are exposed this way, may even threaten your physical safety, as people are saying, you know, let's physically attack those who are voicing views that we consider to be appalling. It may also threaten your family members. That can well have a chilling effect on your free speech. So one person's exercise of one person's engagement in expressive conduct is having a negative impact on other people's expressive conduct. And there have been many, many factual situations where that kind of conflict has arisen at the Supreme Court. And the court sensibly, I think, has never created a per se rule of elevating one kind of free speech concern against another, or one kind of free speech concern against a privacy concern. It's said in every situation, we have to consider all of the facts and arrive at a result that will maximally protect all of the rights. And I'd say generally a lot of what is denounced as doxing isn't really under the technical definition, which means revealing fact or information or identity that was not previously known. So if in fact these people are already publicly associated with a certain organization or a certain idea, their name is known, then that's completely legitimate. If it's a fact that is not generally known, such as their cell phone number or where their kids go to school, well, thanks to the internet, probably a lot of that is in fact in the public domain. But if I can just make one additional point, Time Magazine actually commissioned me to write an essay about this, which I did. And it was one of the hardest things that I've ever had to do. It took a long time for myself and my co-author, who is a psychologist, because I think that perspective is very important. Took us a long time to hammer out our thoughts. Because basically we were saying the fact, and it was about cancel culture type responses, including law firms withholding or retracting offers, including the names and images on trucks. And basically our conclusion was that even if you have a legal right to engage in certain expressive conduct, such as putting these students' names and faces on trucks and driving them around Harvard Square or other places, that you probably should not do that. The fact that you have a right to say something doesn't mean that it is right to do so. And we urge self-restraint in order to promote what we call a free speech culture as opposed to a cancel culture. Certainly cancellation in the sense of not offering somebody a job or retracting a job offer, that doesn't violate any legal right. Indeed, you can say it's consistent with First Amendment values. You have freedom of association to choose with whom you want to associate in this great law firm and with whom you do not want to associate. So it's not a matter of legal right, but on the other hand, if we have such a pervasive climate of people being so afraid of voicing a view because of the disproportionately harsh punitive consequences that are being meted out, losing jobs, losing academic opportunities, shaming, shunning, being ostracized, losing friends, losing social opportunities, that's just not healthy. And every survey that is done shows that on campuses and in other sectors in our society, people are just not daring to talk about the most important issues. The Fire and College Pulse survey that I mentioned recently showed that on the vast majority of campuses, a substantial majority of students say that they cannot have a candid and frank conversation on their campus about abortion, about immigration, about anything to do with race, about anything to do with gender, anything to do with police practices. I mean, this is really a tragedy. So I urge self-restraint on the part of all of us. The fact that you may have a right to engage in doxing, please think about the longer term consequences. Is this contributing to a cancel culture and undermining the free speech culture to which we should aspire?
Great. I want to leave time for the audience to ask questions, but my last question is, thinking back to your time at S&C, have you drawn off of that in the course of your, illustrious career in any respect? And if so, how and what advice would you give?
Well, I want to salute Karen Chung, whom I feel is such a friend, even though we just had the pleasure of meeting in person for the first time, because Karen interviewed me about 6 months ago for the Alumni magazine, as well as helping to organize this very appreciated gathering. And I have always been very, very grateful to Sullivan and Cromwell for the experience that I had as a lawyer. I've not kept up, so I don't know if my experiences are being replicated now. But when I decided to work at a Wall Street firm, I did not intend to necessarily have an entire career at the firm, but I thought it would be outstanding training in the development of professional skills and personal skills that could translate elsewhere. I mean, I think I did a good job for my clients, but it was also like a continuing educational and professional training opportunity for me. At the time, Sullivan and Cromwell had a reputation for, in contrast with the other Wall Street firms, of thinly staffing its litigation cases, and that was absolutely my experience. From my very first day in the firm, one of my assignments was to work with a wonderful partner. I don't know if his name is still remembered, Marvin Schwartz, on a trial. And he said to me, you know, you can choose which witnesses you'll examine and which ones you'll cross-examine. I mean, this is so contrary to the stereotype of carrying somebody's briefcase. And I indeed had a huge amount of responsibility. And I continue to believe that you will rise to the level of the responsibility that you're given. The other excellent aspect of working at S&C was its then, again, I don't know if this is still true, very generous support of pro bono activity. And I was, throughout my time here, very, very active as a volunteer attorney for the ACLU. I wrote a number of friend of the court briefs to the Supreme Court for the ACLU in very major cases, including First Amendment cases.
That's great. Great. Well, let me open it up to the audience here. Steve. Hold on, Steve, we have a microphone for Zoom.
So Nadine, would the ACLU still hire you as their president today or not?
Well, hire it. Okay, let me mince words. The presidency is astoundingly a volunteer position. Many people don't know that. I was working full-time as a law professor throughout my entire presidency. Fortunately, there is a CEO, the executive director. The president is elected by the board of directors. But I take your points, Steve, which is that there have been many complaints that the ACLU has lost its way and is not so strongly defending free speech and classical civil liberties. That said, that kind of critique was constant when I was president as well. And in fact, it goes back to the beginning of the organization, and also juxtaposed with the opposite kind of criticism that you're too strongly defending freedom of speech. And in fact, as I was coming down here, I read an article that was carping at the ACLU's phenomenal legal director, David Cole, because David is representing the NRA in a really important Supreme Court case and showing, you know, dissent and dispute and open-mindedness within the organization. The New York Civil Liberties Union, the New York-based affiliate, dissented from the national ACLU's position. But basically, so the ACLU continues to take very controversial free speech cases. I think our most famous or infamous free speech case, many of you have heard of, the so-called Skokie case in the late 1970s, when we came to the defense of a group of neo-Nazis to demonstrate in Skokie, Illinois, a city that had a large Jewish population, many of whom were Holocaust survivors. And I'm sure you understand that the message that was being defended could not have been more antithetical to the ACLU's own values. But it was a hands down winner in the courts of law. 50 years later, just a few years ago, we did exactly the same thing. And I don't think it's as well known as it should be. We defended, notice I still say we, I'm on the advisory council similar to the Academic Freedom Alliance. We defended free speech rights for the Unite the Right protesters in Charlottesville. Believe me, I do speak in audiences that are attacking me and the ACLU for having done that. So Steve, as with every organization, some decisions we will agree with and some we'll disagree with. I'm absolutely confident that the national leadership of the ACLU including David and Anthony Romero, the executive director. Deborah Archer, my successor as president, are very solid. But as is true in many institutions, the younger cohorts are much less supportive of free speech. And this is true across all, it's an ACLU matter, but it goes way beyond the ACLU. It is society-wide. And it applies to every institution that has traditionally supported free speech. We see much less support in the younger cohorts of academia, journalism, publishing, education, culture, librarianship. And yes, civil liberties and human rights groups as well. So I'm absolutely thrilled that there are some younger people in the audience here. But we can't take the support for granted. Institutions that may be solid now are not secure for the future.
Is that Joe?
Yeah.
Hey, Joe.
Nadine, thank you so much for this. Organizations like FIRE, and it seems certainly kind of the media trend these days, really seem to focus on kind of the free speech on campus issue. I was wondering if you could speak a little bit, at least to my mind, to the other side of the coin, which seems to be more of a tight nexus between government speech and restricted speech, which is sort of the book bans, the kind of restrictions on curriculums that happen in elementary schools, middle schools, and high schools that have been going on throughout the country. And if you have kind of a thought on maybe why that doesn't get as much attention from these kind of groups.
Oh, Joe, I gather your name is. Thank you so much. Well, actually, it does get a tremendous amount of attention from these groups. FIRE brought one of the two lawsuits, for example, against the Stop Woke Act and the Don't Say Gay law in Florida, and succeeded in getting winning preliminary injunctions against those. So FIRE, as well as the ACLU, many other organizations are making that issue a very central one. The PEN America has been very active. That's an organization at the intersection of journalism, literature, and free speech. The National Coalition Against Censorship has made that a really important issue. But I'm so glad that you raised it, Joe, because it shows that the truth of an old saying that the vast majority of people believe in freedom of speech for me, but not for thee. And there tend to be a lot of inconsistencies. Many of the conservative Republicans who were, and I'm sorry, for every generalization, there's an exception. Forgive me, I'm engaging in generalizations and I recognize that. But there are many conservative Republicans who mocked derisively snowflakes on campus who were saying, oh, protect me from ideas that make me uncomfortable or speech that is divisive. And yet they turned around and embedded those very same concepts in the raft of legislation to which you've referred that has been passed in states all over the country. If you look at the language in those laws, they outlaw, I'm talking not only books, but curricula or teaching that makes students uncomfortable or that creates division. And so what I really value about the organizations I've mentioned and about the ACLU is that at least we do our best to be ideologically neutral in demanding the same free speech standards, regardless of whose ox is gored. I think one of the best things that I have seen written about some of the state legislation came out in the New York Times a few years ago. And it was co-authored by 4 people. I'm not going to remember their names. One was David French, who's now a regular columnist for the New York Times, Thomas Chatterton Williams, Coleman Hughes, and I'm so sorry, I'm forgetting the fourth person, but they were all, one was a liberal, one was a progressive, one was a conservative, one was a libertarian. They strongly disagreed with each other on the substantive matters of critical race theory and the 1619 Project. In other words, whether these are good or bad, approaches to the curriculum, but they completely agreed with each other that these laws were devastating to academic freedom and to free speech.
Good. I think we have time for one more question. Matt?
My apologies, I came in late, and maybe this was covered, but I'd be interested in your thoughts on bad faith free speech, specifically misinformation that is designed for an end and is not advocacy more than seeking to obfuscate. And, often misinformation is not designed to get you to believe the misinformation. It's to get you to believe nothing, which ends up debasing discourse. So interested in your
that
thoughts.
wasn't covered, Matt, but thank you, because I found in the recent past that disinformation and misinformation, especially on social media, has become the new hate speech. In 2018, I published a book on hate speech because that was the most controversial speech that most people, including most people on the left end of the political spectrum, thought was the most dangerous and wanted to clamp down on. But in the recent past, it's been disinformation, misinformation, even so-called malinformation. And I think that the Supreme Court has gotten it exactly right, Matt, that there is a limited set of false statements, intentionally false statements or recklessly false statements that in context cause or threaten imminent, specific, serious harm that can and should be punished, consistent with general principles that I did lay out earlier. And those include defamation, fraud, perjury. But when you get beyond that to this loose, inevitably subjective concept of misinformation, I think that the danger of empowering government or universities to decide which should be punished is greater than allowing that kind of false or misleading information to percolate. In the United States, before the Supreme Court narrowly circumscribed the concept of punishable defamation in the famous New York Times versus Sullivan, defamation lawsuits were, I'm happy to say this again, the first day of Black History Month, defamation lawsuits were a deliberate strategy that were used by Southern officials to silence the civil rights movement and to silence national media whose coverage was essential for bringing the attention of members of Congress who were then considering the historic 1964 Civil Rights Act. More recently, in the wake of the pandemic, governments around the world, including in Puerto Rico, passed disinformation laws about health disinformation that could endanger public health and help to spread the pandemic. And disproportionately, predictably, those laws were used to suppress any views that were different from the government's official line. The ACLU brought a lawsuit against Puerto Rico's two COVID-related disinformation laws, and we won the lawsuit earlier this year. The federal judge agreed with us that having the most robust expression about COVID or any kind of health emergency is especially important because our clients, by the way, were two extremely respected reporters, investigative journalists, but they said, look, in a late-breaking, fast-paced situation, it's inevitable that you're going to make some mistakes. And if you're afraid that you're going to be subject to punishment under this misinformation law, you're going to stifle your speech, and that's going to adversely affect the public and the right to know and the scientific process of, putting everything out there. And sure, criticize it, critique it, refute it, rebut it, but don't allow the government to invoke this very vague and overbroad concept to outlaw it.
Nadine, thank you so much. This was really a great conversation, and I think was really enriching for everyone who's able to be here in New York and who's watching on Zoom. So thank you.
Well, thank you so much.